Welcome to the Licensing Committee. We have a full agenda, and I'm asked to remind everybody that we're not surfing the net when we've got our computers on, but in fact we have the agenda on electronic format. So with that said, I'd like to call the Licensing Committee meeting to order and ask Ms. Lowe to take the roll.
Dr. Bishop?
Here.
Dr. Carrion? Ms. Chang?
Here.
Dr. Diego?
Here.
Dr. DeRusso?
Here.
Ms. Shipsky?
Here.
Dr. Solomonson?
Here.
We have a quorum.
Thank you. It looks like we shall begin with some public comments not on the agenda. I've been given some speaker slips. If anyone else would like to speak on non-agenda items, please. So I'd like to begin with Mitchell Feynman. Dr. Feynman?
Is that not on the agenda or on the agenda?
Oh, I'm sorry. You handed them to me too soon. Okay, any items not on the agenda? Any speakers? Okay, alrighty. 12 will be an interesting, vigorous discussion. Seeing none, let us move on to, I think we should have, indeed, approval of the minutes from the February 12th, 2012 meeting.
Motion to approve.
Any additions or corrections? Any public comment on those minutes? May I have a motion to approve the minutes?
So moved.
And a second?
Second.
Okay, all in favor of the minutes?
Aye.
Aye.
Any opposed? The minutes are approved. February 2nd, 2012. Thank you for the correction.
Actually, I think it's.
That's not correct?
I think it's May 3rd.
Oh, well, that'll teach me to use a cheat sheet. There it is, May 3rd. I stand doubly corrected. Thank you. Am I using the right script? Yes, Thursday, July 19th. Okay. So now an update on licensing. Mr. Warden.
Okay, I would like to start off with updating you on the licensing staffing. First, I'd like to thank staff for doing an excellent job this past fiscal year. They did a tremendous amount of work and did it quite well. We currently have 3 vacant positions, which is the lowest we've had in a long time, and actually 2 of those positions are filled, and the people will be starting them on Monday. So that leaves us down to 1 vacancy in licensing. And we recently filled several positions, including a cashiering position, licensing position in the front end that helps initialize the initial process of applications, an additional international medical school analyst to work on international medical school recognition. That was a promotion for one of our analysts, so we backfilled that position, his position, with another person from within licensing, which caused the vacancy for my assistants. So that position has been advertised, and we'll be interviewing for that soon. We also hired 2 U.S. file reviewers and 1 limited term file reviewer for U.S. applicants. And upcoming challenges for licensing program regarding staffing is which will probably cause delays in the licensing workloads numbers, is that staff now must take 1 furlough day per month. That equates to 376 hours of lost productivity per month for licensing. That adds into a total for 4,512 hours of lost productivity for the fiscal year. Staff also must take 2 personal development days in addition to that, and that adds another 752 hours of lost productivity, and that's for a total of 5,264 hours of lost productivity that we'll experience this fiscal year from different types of furloughs and required days off. So that does not include our retired annuitants or assistants. That's just our permanent staff. Another thing that's going to impact licensing is all of our student assistants cannot work past August 30th. So we will lose we have currently 6 students working for us, and we will lose their ability to work for us at the end of August. And then we also have 7 retired annuitants working for us, and with the licensing, or the state's only allowing what they consider to be mission critical retired annuitants to work. We have submitted them as mission critical, but we're still waiting for the answer on that. And if they can only work until August 30th unless they have been declared mission critical. And we also currently have approximately 12 licensing staff that are in some form of training for their jobs. And in addition, we have 4 staff on leave. Fortunately, one of them plans on returning on August 1st. The managers and I will continue to work on our goals and trying to maintain and make adjustments to maintain our goal of 45 days for initial reviews. And that concludes my update on staffing.
Thank you. Any committee member comments on staffing or questions? Any public comments? Then I think we can move on to the update on the business process re-engineering recommendations. Again, Mr. Warden.
Okay. So the staff has continued to work on the physician and surgeon's application and developed a new application fee and checklist. The latest draft of that has been submitted to us from our last revision of changes, and that will be reviewed by executive management in the next few weeks. Hopefully we're getting towards the end of that. It has had legal review previously. We're just double checking most of our work right now, and we plan on rolling that out very soon. Once that's been able to be rolled out, we're going to try to do the updates on the website, which is the main next step. So the website will be updated to include all those things, and we also plan to have maybe a interactive question thing for the new physician application to help answer some of the questions that they can click on, and it will tell them why they need to mark box for the criminal record checks and the boxes. So that was planned for that. And then the update on the policy and procedures manual is that's sort of been put on hold while we're doing other things with different priorities. However, some of that is also because we don't have the new application finished and we don't want to recreate it twice. We do have a new program for PolySom, and the policy and procedures are being drafted in that, and we'll be testing them out with our new applicants. I'm making sure that we got everything covered on that. That concludes my report on that.
Well, thank you. And I just, on a sidebar, have to say I just did the reapplication process personally online, light and fast. And so, and I'm not that computer savvy, so my kudos to your work on that. And hopefully the new applicants will find it equally pleasing. Any other committee members? Comments? Public comments? Thank you. Then I believe Ms. Lowe is going to give us an update on the implementation of SB 100, which is the outpatient surgery center requirements for the licensing program.
Good afternoon. This is to provide you with a status report on the progress being made to implement Senate Bill 100 regarding outpatient surgery settings. And if you could please refer to page 100 of your board packets. And before I get into the status of the implementation of SB 100, I'd like to provide some history on the laws regarding the outpatient surgery settings. Currently, California law prohibits physicians from performing some outpatient surgeries unless it is performed in an accredited or licensed setting. Existing law specifies that on or after July 1st, 1996, no physician and surgeon shall perform procedures in an outpatient setting using anesthesia except local anesthesia or peripheral nerve blocks or both, complying with the community standard of practice in doses that, when administered, have the probability of placing a patient at risk for loss of the patient's life-preserving protective reflexes, unless the setting is specified in Health and Safety Code Section 1248.1. Outpatient settings where anxiolytics or analgesics, told you I would mess that up, are excluded when administered in compliance with the community standard of practice in doses that do not have the probability of placing the patient at risk for loss of the patient's life-preserving protective reflexes. As outlined in Health and Safety Code, certain outpatient surgery settings are excluded from the accreditation requirements, such as ambulatory surgical centers certified to participate in the Medicare program under Title 18, health facilities licensed as general acute care hospitals, federally operated clinics, facilities on recognized tribal reservations, and facilities used by dentists or physicians in compliance with Article 2.7 or Article 2.8 of Chapter 4 of Division 2 of the Business and Professions Code. Pursuant to Health and Safety Codes, the Board has adopted standards for accreditation and in approving accreditation agencies to perform the accreditation of outpatient settings, ensuring that the certification program shall include standards for multiple aspects of the setting's operations. The Board has approved the following 4 accreditation agencies: American Association for Accreditation of Ambulatory Surgery Facilities Incorporated, Accreditation Association for Ambulatory Health Care, the Joint Commission, and the Institute for Medical Quality. Current law provides that any outpatient setting may apply to an accreditation agency for a certificate of accreditation. Accreditation shall be issued by the accreditation agency solely on the basis of compliance with its standards as approved by the Board under Chapter 1.3 of the Health and Safety Code. Pursuant to the enactment of Senate Bill 100, which became effective January 1st, 2012, Health and Safety Code Section 1248.2 B, C, and D now provides that the Board shall obtain and maintain a list of accredited outpatient settings from the information provided by the accreditation agencies approved by the Board, and shall notify the public by placing the information on its internet website whether an outpatient setting is accredited or the setting's accreditation has been revoked, suspended, or placed on probation, or the setting has received a reprimand by the accreditation agency. The list of outpatient settings shall include all of the following: the name and address and telephone number of any owners and their medical license numbers, the name and address of the facility, the name and telephone number of the accreditation agency, and the effective and expiration dates of the accreditation. Approved accrediting agencies are required to update the Board on any new existing settings, as well as to provide updates on current settings. The database will be used to reflect current and future information and will not be a historical reference for past actions that may have occurred. Prior to Senate Bill 100, data was reported to the Board from the 4 accrediting agencies. However, it was not done in a consistent manner. We've now updated the reporting requirements, and data is being provided from all 4 at this time. SB 100 also requires the Board to investigate complaints related to a violation of Health and Safety Code Section 1248, and upon discovery that an outpatient setting is not in compliance with a specific provision, bring an action through or conjunction with the District Attorney to enjoin the outpatient setting's operation. The Board's licensing program is currently working directly with the Board's enforcement program to ensure that any complaints or adverse actions reported are reviewed and investigated as required by law. Further details on these processes and the procedures for handling complaints and actions will be presented by Ms. Katie in the Enforcement Committee meeting. Meetings were held between the Board and representatives from the accreditation agencies in order to determine the logistics of obtaining their accredited settings data. Standard templates were provided to the agencies, and data was provided in electronic format, which is compatible with the database design that we have been working on. Data has since been obtained, and has been imported into the database. However, staff is currently working with the accreditation agencies to obtain additional information that has not been provided. We did go live with the database on July 18th, and it is now available from the board's website. As additional data becomes available from the accreditation agencies, board staff will be updating the records accordingly. Currently, though, if we've not received data as required, the fields in the database will reflect none reported. The board's IT staff is still improving upon the database and will continue to enhance the features, which will include incorporating the ability to view documents such as final inspection reports, plans of correction, and corrective actions completed. And although the documents are not available on the website at this time, consumers can contact the licensing program to obtain copies of those public documents if necessary. And now that the database has been released, the board will begin the process of notifying consumers of the availability by providing information in the board's newsletter, sending out information in an email via the board's subscriber list, and providing links to the database from the board's website homepage. So I can now show you the database, but just please keep in mind it is still a little bit of a work in progress. So right now, the only way to access the actual search feature is going to be through the outpatient surgery settings web page, which is already out on the web. It's just been updated with the new information. It has the information regarding what's required by SB 100 and the different accreditation agencies, and does indicate in the disclaimer that this information is being displayed is what is being provided from the accreditation agencies. It is not our data. We're not manipulating any of the data, and that's why you'll see multiple fields are reporting. Nothing was reported for that at this time. So when you open up the database, it's going to give you brief instructions on the different search features. You're at this time able to search by a setting name or an owner name. In the future, we will be enhancing it to also allow you to search by accreditation agency. Pushing the wrong button. Okay, so the search feature allows you to do keyword searches, character searches, or actual names of the facilities or owners. And it'll provide you with all of the settings for the 4 different accreditation agencies across the board. We have it separated up here by the 4 different types. If a setting is accredited by multiple accreditation agencies, there'll be multiple check marks reflected. I'll go ahead and select one. When you select the facility, I'll pull up the information, and all of the required fields for SB 100 are included in this, with addition of other fields that we felt would be useful information to the public, including the doing business as. There's quite a few settings that will be accredited doing business as another business name. Also, setting types will be listed, and specialty types. If there's multiple specialties, all of the different specialties for the settings will be listed, and all of the owners will be listed as well. Once you pull up a setting, if you want to review a owner's information, you can click on that directly, and it'll take you to their profile information in the database. You'll see that we have the owner's name listed, but we don't have a lot of the additional fields that we've asked for. This is something that we're continuing to work on with the accreditation agencies. So you're able to go from one record to the other. You can go from a setting to the owner and then see what other settings they're associated with as well. And it'll just continue to go on. So we're very happy to be able to have it out there to the public, and we'll continue to work on it and obtaining the additional fields of information from the accrediting agencies. So,
Thank you. I'm going to specifically ask Dr. Bishop if he has any comments, because I know he has a lot of expertise in outpatient surgery.
Nothing specific. I worked in Virginia for a number of years in facility. And we were accredited by Joint Commission, but I think I'm not aware of any great differences between the different accrediting agencies. I think it's a good thing.
Very good. Any other comments from committee members? Dr. Carrion, any comments? Again, another surgeon, like your perspective.
My experience in my early years as a surgeon was that some of these surgical centers, they didn't pass one of these organizations, and they moved to the next,
Right.
and then moved to the next until they got some license.
Mm-hmm.
And usually those surgical centers were the ones who they really had problems. Now I think it's a little bit different. They are a little bit more strict, right?
they do have additional requirements that have to be met through the accreditation agencies, and there's also laws in place that say if one accreditation agency denies accreditation, they are able to go to a different accreditation agency. However, they have to disclose the reasons why they were denied from the one.
Okay,
So,
that's very good. We're making progress.
hopefully.
Thank you. Any other comments from committee?
I have a comment also. Thank you. How about these agencies or the settings where they're not required to be accredited by us? How are those being monitored? You know, the comment about certain outpatient surgery settings are excluded.
There
not?
are
Is it
there are certain outpatient settings that are licensed through the Department of Health, I believe, and there's a feature on our website as well that you can click to.
so they have their own licensing regulations?
Just not
Yeah.
through us or through the accrediting.
Thank you, Dr. Abel. Good question. Any other committee questions? I don't see any speaker slips from the public regarding this item. So with that, I'm going to thank Ms. Lowe, but she's not going far because she is going to present on the allied healthcare professions.
So I'm going to need just a minute to set up the PowerPoint. This is to provide you with an overview on the allied healthcare professions that are regulated by the Medical Board of California as part of Strategic Plan Objective 2.9. I'll be providing a PowerPoint that you can follow along with in your board packets, starting on page 101. The board is responsible for the licensing and regulation of licensed midwives, the RDO program, including the registered dispensing optician, spectacle lens dispenser, contact lens dispenser, and non-resident contact lens dispenser registrations. The registered polysomnographic program, research psychoanalyst, student research psychoanalyst, and medical assistants, which are regulated but not licensed by the board. I'll be providing an overview of each program individually, so if you can bear with me. I'll go ahead and begin with the licensed midwives. A licensed midwife is an individual who has been issued a license to practice midwifery by the Medical Board of California. The license authorizes a midwife to attend cases of normal childbirth in a home, birthing clinic, or hospital while under the supervision of a physician and surgeon, specifically an OBGYN in active practice. The licensed midwife provides the necessary supervision, care, and advice to women prior to and during pregnancy, labor, and the postpartum period, conducts deliveries and cares for the newborn infant during the postnatal period. This includes preventative measures, protocols for variations and deviations from norm, detection of complications in the mother and child, the procurement of medical assistance when necessary, and the execution of emergency measures in the absence of medical help. The standard of care for California licensed midwives document is available on the board's website and further clarifies the standards required of a licensed midwife in California. There are two pathways that one can undergo to become licensed in the state of California as a midwife. The first pathway would be education, which requires one to complete a 3-year post-secondary education program in an accredited school approved by the board. And currently there are 15 schools approved by the board within the United States. The second pathway would be by challenge mechanism. Business and Professions Code Section 2513 A through C allows a midwifery student and prospective applicant the opportunity to obtain credit by examination for previous midwifery education and clinical experience. And there are currently only 2 challenge programs that are approved within the United States at this time. Once an individual has met the educational or challenge requirements, they must take and pass the North American Registry of Midwives, or NARM, examination. The examination was adopted by the board in May 1996 and satisfies the written examination requirements as outlined in law. The exam is given twice yearly and is held at the medical board's headquarters. And although staff coordinates and proctors the exam, material is provided directly from NARM and returned to them for processing. The board does not determine the exam material nor determine if an individual passes or not. In order to apply for a midwife license, an individual must submit an application form, which is available online with a fee of $300. And upon review of the application, if the individual meets the licensure requirements set forth by law, a license will be issued. Renewal of the license is every 2 years and requires the midwife to pay the fee of $200 and to submit the renewal form certifying completion of 36 hours of continuing education. Also, as part of the renewal process, the licensed midwife annual report must be completed and submitted directly to OSHPD. Data submitted on the licensed midwife annual reports is compiled by OSHPD and then provided to the medical board, which we will then publish in the board's annual report. In the last fiscal year, there were 40 new licenses issued, with a total of 252 with active licenses.
Oh, before we move on, if we could take the prerogative of taking each of these specialties as a separate item, if we could. Any questions regarding the midwifery program? Okay. Well, no, I do, and I can't help it because there's a verb in there, supervision, which comes up with
There is very few OBGYNs today that I know that they supervise midwives. I don't supervise midwives. In the hospital that I work at, we have an average of 500 deliveries a month. No doctor supervises midwives.
So I guess my question is, I'd like to know that this legal requirement is being carried out, because if we are the authorizing entity, namely the medical board, that are issuing the licenses, then I'd like assurance that those practicing midwives are fulfilling their part of the equation, which is to have adequate supervision, and again, we may need regulations to flesh that out. Then I may be looking at Ms. Shipsky, because she knows how we wrestle with that word supervision in the other committee, and I just want to make sure that we are fulfilling our mandate or the law that is being fulfilled.
Well,
that would
Chair, I think the other thing is that we also need to differentiate between licensed midwives and certified nurse midwives, which are in a total different capacity.
Right. I don't think we're talking about
So we're talking about
those.
license, but a lot of people don't understand there is a
That's true too, but we don't have jurisdiction over those, am I
No, but
correct?
these individuals do home births, and the physicians are not present at the home birth.
Yeah, no, I'm just
That's not the
concerned.
licensed ones, right?
They are licensed. The licensed
I'm concerned
midwives-
about the ones that we have issued a license for, and apparently the legislation said that they are to be supervised by an active OBGYN, if I understand that slide correctly, and I'm just wanting to make sure that that
But again, the
legislation is
definition
being...
of supervision is very fluid because in the case of licensed midwives, they attend home births or birthing centers. Their physicians are not present there. So when we talk about direct supervision, they are not there. And my understanding that Kurt would like to weigh in, but they have a capability in terms of telephonic contact and obviously referral if there's a difficulty. But when we wrestle this thing about laser and other things, there is no on-site supervision.
So I'm just wondering what the legislature had in mind, and are we, if we're issuing these licenses, sure that the compliance is occurring? And I'm not sure what comes back on those reports that you alluded to, what information they're being, we're being given.
The actual supervising OBGYN is not provided to us. And it does say in law, though, that supervision shall not be construed to be required, to require the physical presence of the supervising physician on the premises. So they don't have to physically be there, but further definition of supervision probably does need to be made.
That's a work in progress. The board has struggled with numerous sets of regulations, attempted numerous times to define the appropriate level of supervision as required in Section 2507, has so far been unsuccessful in promulgating regulations to that effect. Not for lack of effort, though.
Well, wasn't
Go ahead.
at one point that was told to us that the insurance company are not insuring the OBGYNs if they take up a midwife to supervise the midwife? Is that correct, or is that a correct
That's what they've
statement now?
reported every time.
Yeah.
So basically, then the legislatures have set up a situation that is not possible to have, I guess, unless you can find some OBGYNs who would like to not have malpractice coverage.
So my comment is, in the only thing that we need to worry about is, do they have supervision? In order for us to issue a license, they have to have supervision. And if they don't have supervision, then we shouldn't issue a license the way the regulation states, right? I mean, that's, whether they should or shouldn't be present, not be present, the insurance get it, it's just what is stated to us is, in order to get a license, they have to have supervision. And if that's not happening, then we shouldn't be issuing licensing, and then we should go back to the drawing board and figure that one out, right?
Janet,
Thank
my
you. That's
suggestion is that at the moment we issue the license for the midwife is going to name Dr. ABC, and the board is necessary to contact those doctors and be sure that they are supervising the midwife. That is the only way that we are going to protect the public.
Respectfully, Madam Chairman and members, I think we're straying a little bit off topic here. This is supposed to be a sort of an informational, disclosure about the people that we license, the medical license, other than physicians and surgeons. If the board or if this committee wants to take a look at the licensing requirements of a licensed midwife in case any regulatory or statutory recommendations or changes about having the supervision or disclosure of the supervising physician at the time of application or licensure, I would respectfully suggest that we agendize that perhaps formally at the next meeting, but it's
I appreciate that. I appreciate that very much, and like to suggest that someone might want to have that put on the agenda to make sure that our licensees are in compliance with the law.
Right. But wasn't there something that the midwife committee is working on this exact same subject of supervision right at this moment?
But it doesn't matter if they're working on it or not. I mean, eventually it'll get flushed out and settled, but for right now, this is how the law states. And so I would like to put that on the agenda.
Thank
Can we do
you.
that in conjunction with the advisory committee on midwifery? Because we have an advisory board on this entire
They're
subject.
working on it, so.
Well, I don't
And
think,
currently, the Midwifery Advisory Council is working on the supervision of student and assistant midwives by other midwives. It's not the
okay, well, that
physician
sounds like
involved.
it's two different things, and a two-pronged attack doesn't seem wrong, because one is kind of a procedural thing, which I think is in the domain of licensing. So I'd like to accept that agenda item, but please, Dr. Diego, if you bring that up at the right time when we ask for new items, please recall that. Any comments further? Then I guess we'll move on to the next specialty, which the optician program.
Correct, the Registered Dispensing Optician Program. So this program is comprised of 4 different sections. There's the Registered Dispensing Optician, which is for the business, contact lens dispenser, spectacle lens dispenser, and a non-resident contact lens dispenser registration. The Registered Dispensing Optician, also known as the RDO, is required for any individual, corporation, or firm engaging in the business of filling prescriptions of physicians and surgeons, osteopaths, or optometrists for prescription lenses. This registration is for the actual business location. In order to conduct business or fill prescriptions at the RDO must employ a spectacle lens and or a contact lens dispenser. And the RDO cannot stand alone without the other types of license registrations.
Interesting.
In order to apply for an RDO registration, an individual must submit the application form, which is available online with a fee of $75. And upon review of the application, if they meet the business requirements set forth in law, and includes information on the spectacle lens dispenser and or contact lens dispenser that will be working there, a registration will be issued. Registrations in California. The spectacle lens dispenser registration is required for any individual working in an RDO who's fitting and or adjusting spectacle lenses. Spectacle lens dispenser cannot stand alone, again, without being associated to that RDO. To obtain spectacle lens registration, there's not an educational requirement set. However, they must take and pass the American Board of Opticianry, or the ABO examination, which is given twice yearly. This examination was adopted by the board and satisfies our written requirements as outlined in law. In order to apply for spectacle lens registration, an individual must submit the application form, which is available on our website with a fee of $75. And again, if they meet the requirements in law, we'll issue the registration. The renewal is also 2 years and is $75. And
Fees and how often are they evaluated?
There may be a readjustment of fees unless we're at a statutory cap, for example.
Thank you.
so in the last fiscal year, there were 196 new spectacle lens dispenser registrations issued, totaling 2,182 with current registrations. The contact lens dispenser is much like the spectacle lens dispenser. It's for the individual working in an RDO They cannot stand alone without being associated, and it's used for those fitting and adjusting contact lenses. Again, there's no set requirements for education. However, for contact lens dispensers, they must have taken and passed the National Contact Lens Examination, the NCLE, which is also given twice yearly. And the exam also meets the requirements of the board. And again, in order to apply for this, one must submit an application, which is available online. The fee is $75. And the renewal for this is every 2 years with a renewal of $75. Last year, there were 73 new registrations issued, currently 902 with active registrations. The non-resident contact lens dispenser is required pursuant to Business and Professions Code 2546.1, which is required for any individuals, partnerships, or corporations located outside of California that ship, mail, or deliver contact lenses at retail to a patient in the state of California. With regard to any person subject to registration pursuant to this, only replacement contact lenses provided may be provided pursuant to a valid prescription may be shipped. In order to apply for the non-resident contact lens dispenser, they must submit the application with a fee of $100. For this, there are additional requirements because a lot of these are online businesses, so we make them submit proof of a specific warning that's required by law, as well as proof of an 800 number available for consumers. And they also have to show current active registration within the state that they are if they have laws requiring it for businesses selling contact lenses. The renewal is also every 2 years for this, and the fee is $100. Last year, we did not issue any new registrations for this. There were a total of 11 current last year. I do know of a couple that are coming through right now. I think we've recently issued one, and we have one that is about to be issued. I believe that we'll be seeing more of these types of registrations with the internet sales, and I'm sure this number will be going up.
Any questions on any of the optometry specialties? Okay, thank you. We'll have you move on then to the polysomnographic program.
Okay. The polysomnography is a treatment, management, diagnostic testing, control, education, and care of patients with sleep and wake disorders. This is a new program to the medical board that we began regulating in February of 2012, so it's new to all of us. Polysomnography includes, but is not limited to, the process of analysis, monitoring, and recording of physiologic data during sleep and wakefulness to assist in the treatment of disorder syndromes and dysfunctions that are sleep-related, manifest during sleep, or disrupt normal sleep activities. Under the polysomnography program, there are 3 types of registrations that can be obtained. There's the polysomnographic trainee, the technician, or the technologist. The registered polysomnographic trainee registration is required for individuals under the direct supervision of a supervising physician and surgeon, polysomnographic technologist, or other licensed healthcare professional who provides basic supportive services as part of their educational program, including but not limited to gathering and verifying patient information, testing, preparation, and monitoring, documenting routine observations, data acquisition and scoring, and assisting with appropriate interventions for patient safety in California. In order to qualify as a polysomnographic trainee, one must have either a high school diploma or GED and have completed at least 6 months of supervised direct polysomnographic patient care experience, or be enrolled in a polysomnographic education program approved by the board. They must also possess at the time of application a current certificate in basic life support issued by the American Heart Association. The registered polysomnographic technician registration is required for individuals who may perform the services equivalent to that of a trainee under general supervision and may implement appropriate interventions necessary for patient safety. In order to qualify for the technician registration, an individual must meet the initial requirements for a trainee and have at least 6 months experience at the level of a trainee. The polysomnographic technologist registration is required for individuals who are under the supervision of a physician and surgeon, are responsible for the treatment, management, diagnostic testing, control, education, and care of patients with sleep and wake disorders in California. Registration requirements include having a valid credential as a polysomnographic technologist issued by the Board of Registered Polysomnographic Technologists. They shall have graduated from a polysomnographic educational program that has been approved by the board and shall have taken and passed the Board of Registered Polysomnographic Technologists examination given by the Board of Registered Polysomnographic Technologists. However, on this requirement, if we receive an application on or before October 22nd, 2012, in lieu of this, submission of documentation from the supervising physician indicating that the individual has engaged in the practice of polysomnography safety for 5 years will be accepted in lieu of that. Again, in order to apply, the applications are available online. The application must be submitted with the application fee of $200, and upon review, if they meet the requirements in law, we would issue the registration. Renewal is every 2 years, and at the time of renewal, the form must be submitted with a fee of $150, and again, verification of the basic life support is required at the time of renewal. And we have not yet issued any polysomnographic registrations at this time. However, we do have applications pending or are in the process of getting those issued.
Madam Chair, do we have a definition of what constitutes supervision for these folks?
Well, you're not.
No.
I noticed the word direct was in there a time or
Only
two.
on one of them. The other one was general supervision. And having undergone this kind of testing, there are no physicians present on those facilities. These are all done by tech. So when we are trying to grapple with the issue of
We want
what we're
parallel.
calling about supervision, it is across the board. It
Yeah.
is
Oh, no,
not.
that's why I'm saying that we grappled with that with the laser as well. So no, absolutely parity.
I just like to say, to reiterate what I've said at the prior committee, I think that the concept of supervision should not be compartmentalized to any specific discipline, any specific location. The concept of supervision is a generalized concept that has to be based on a few general principles that I won't elucidate again today. If you want to hear those, we spoke about this last time, the supervisory committee, and I'll speak about them again today. But I think reproducing this discussion again and again really is not reasonable. We should have one basic definition of supervision.
Yes.
It's a concept that's not difficult. In my profession as an anesthesiologist, I supervise anesthetists and have done for 20 years. And it's a very clear concept, I think, within the medical field with great background. So I think we should really try to grapple this with all of our licensees.
I appreciate that. Thank you.
Well, and the other thing, are we making a requirement on this for these people to disclose who their supervising physician is? No. So if we are going to make these changes for other licensees, it seems to me we need to do this across the board. Otherwise, we are singling out
I agree.
an area.
So the optician people have to disclose where they're practicing. They can't do a standalone. Correct. So, there's...
That's a corporate indication of where they're dispensing from, not necessarily requiring an ophthalmologist or an optometrist to certify that they're supervising them in any way.
Right.
They're really
Supervision.
free agents in many ways.
Right.
Yeah.
If I could just for a moment, Ms. Shifsky is exactly right. The RDO program is uniquely distinct, and it's one of the few licenses / registration / permits we issue to actually bricks and mortar physical location. Most of the licenses we issue are personal.
Right.
Okay. Any other comments on the polysomnographic program?
The only thing is, I see where the trainee and the technician and the technologist, the trainee and technologist seem to have more defined duties, but I don't know what, for the technician, what appropriate interventions mean.
Just a second. This is Mr. Salgado, also a licensing manager, and he worked on the regulations for the Polyson program.
Basically, the technician is a position outside of the trainee who has accomplished the education. The trainee is a person who's still in the schooling, and so a technician would be one who completed the school but yet has not had 6 months of experience outside of the school.
What I'm more concerned with is the technician may implement appropriate interventions necessary for patient safety, and I don't have a good sense of what appropriate interventions are.
It usually means to the State Apnea Center that they can initiate CPAP.
Or wake them up.
Or wake them up.
Oh, that's
Right.
Jaw lift, sleep back.
okay. All right.
We'll be getting more information out on that, not only to us, but also on the medical board's website on what can and can't be done. So.
Okay, fine, thank you.
And I have a comment in regards to the supervision. These individuals are not just supervised by physicians, surgeons, but they can be supervised by the polysomnographic technologists that we approve and by other health care professionals. So we'll more define the supervision, but it's not just physicians and surgeons that are the only people who supervise these individuals.
Okay, so we'll be moving on to research psychoanalysts and student research psychoanalysts. A research psychoanalyst registration is required for any individual engaging in psychoanalysis as an adjunct to teaching, training, or research. Additionally, students who are currently enrolled in an approved psychoanalytic institution are registered with the medical board as student research psychoanalysts, and they may engage in psychoanalysis under supervision. Again. Psychoanalysis is defined as a method of analyzing psychic phenomena and treating emotional disorders that involves treatment sessions during which the patient is encouraged to talk freely about personal experiences. Registration requires that an applicant has a doctorate degree or its equivalent and has graduated from a psychoanalytic institution approved by the board. There are currently 19 approved psychoanalytic institutions that have been approved. In order to apply, one must submit an application with a fee of $100, and the renewal for this program is every 2 years and requires a $50 renewal fee. Last fiscal year, we issued 8 new registrations for psychoanalysts, analysts, and there are currently 92 with active registrations. And now, last but not least, our medical assistants. Medical assistants are unlicensed individuals who perform non-invasive routine technical support services under the supervision of a licensed physician and surgeon or podiatrist in a medical office or clinic setting. Medical assistants are not licensed or registered through the medical board, however they are regulated. They may obtain certified status through a private agency approved by the Medical Board of California. Currently, there are 3 different approved certifying agencies. Medical assistants may perform non-invasive routine technical support services under the supervision of a licensed physician and surgeon or podiatrist in a medical office or clinic setting. The supervising physician and surgeon or podiatrist must be on the premises in order for the medical assistant to perform those non-invasive technical support services. And I've provided some examples of what are and are not in the scope of practice for a medical assistant. Training for a medical assistant can be under 2 different ways, either under the licensed physician or podiatrist, or a registered nurse, a licensed vocational nurse, a physician assistant, or qualified medical assistant. That'd be basically hands-on training in the office. Or they can obtain training through a secondary, post-secondary, or adult education program. Supervision for medical assistants are a little bit more defined. In every instance prior to administration of medicine by a medical assistant, a licensed physician or podiatrist or another appropriate licensed person shall verify the correct medication and dosage. The supervising physician or podiatrist must authorize any technical supportive services performed by the assistant, and the supervising physician or podiatrist must be physically present in the treatment facility when procedures are performed. And that concludes my presentation. Are there any questions?
They're unlicensed, so then they just register with us?
They're not even required to be registered through us.
Okay, so then this was for point of information what they could not do because they're unlicensed?
They are not licensed by the board or certified, however, they're regulated in law, so if there was an issue with a medical assistant,
Got it.
we would be able to
Okay.
look into that.
Helpful. Thank you. Any other questions? All right. Well, thank you, Ms. Lowe. Any public comments on this topic? Well, then I think we're not letting...
I do have one
Oh,
question.
thank you.
It dawns on me that they're not licensed, or really, what sort of disciplinary measures do we take if we had a problem?
I think it's against the doctor.
Yeah.
It would be against the
correct?
supervising individual. Then.
Yes,
I see.
correct.
Okay, so I'm just want to
Who
clarify.
shall go unnamed?
What?
Dr. X.
Part of the board strategic plan 1.1, and if you could please refer to page 102 of your board packets. The board has adopted and administers standards for the continuing education of physicians and surgeons licensed in the state of California. The board requires each licensed physician and surgeon to demonstrate satisfaction of the continuing education requirements at intervals of not less than 4 nor more than 6 years. Currently, each physician is required to complete not less than 50 hours of approved CME during each 2-year renewal period immediately preceding the expiration date of their license, except as permitted by current law, which states that any physician who takes and passes a certifying or recertifying examination administered by a recognized specialty board shall be granted credit for 4 consecutive years of continuing education. Approved CME consists of courses or programs designated by the American Medical Association or the California Medical Association as Category 1 credits, which are related to one of the following: patient care, community health or public health, preventive medicine, quality assurance or improvement, risk management, health facility standards, the legal aspects of clinical medicine, bioethics, professional ethics, or improvement of the physician-patient relationship. Physicians are required to sign a certification statement indicating that they have complied with the requirements, as well as answer statements related to the CME that they have received as part of the renewal process. If the certification statement is not signed or any of the CME statements are not completed, a hold will be placed on the license and the renewal will not be completed. Follow-up to the renewal deficiencies is performed by the cashiering unit of the board as well as Department of Consumer Affairs cashiering unit. At the time of renewal, documentation of hours is not required. However, Title 16 California Code of Regulations, Section 1338, does require the board to audit a random sample of physicians who have reported compliance with the continuing education requirements. If selected for the audit, proof of attendance at CME courses are required to be submitted. And if a physician fails the audit, by either not responding or not meeting the requirements set forth in law, the physician will not be allowed to renew their license. The physician will be allowed to renew their license one time. However, following that period, they will not be able to any longer. Furthermore, a physician may be charged with unprofessional conduct for misrepresenting compliance with the CME requirements. And in the past, the board performed the CME audit once annually. And this kind of gets into the history of the audit. It was performed one time a year, which was a major endeavor for board staff because the process was mainly a manual process. It resulted in the audit taking an average of 6 to 9 months from start to finish, and once the audit was completed, it would be starting all over for the year, for the next year. With the advancements in technology and the experienced IT staff that we have at the board, the process to complete the audit has now been mainly automated. It was revamped in January of 2011. Currently, the audit is able to perform an audit of approximately 10% of physicians and surgeons with current licenses in California. The process to select the physicians and surgeons to undergo the audit is now an automated computer-driven procedure based on requirements that are programmed into the reporting system. Upon receipt of documents, the process is still the same in that it is manually reviewed by staff to ensure compliance is obtained prior to the next renewal period. The new process is much more streamlined and efficient, and it's allowing us to audit more physicians to determine compliance, which will allow in the end better consumer protection by ensuring that the physicians are meeting the requirements for continuing education. In 2011, there were over 10% of the physicians audited that had failed. We're always looking at ways to improve numbers. And some ideas that we are looking at in the licensing program is to provide additional information to physicians and surgeons about the available opportunities for continuing education and the requirements that are set forth in law. The board's strategic plan, Objective 3.1, does mention that conduct outreach to various organizations such as hospitals and group practices through providing speakers or articles for their publications. And this may be something that the licensing program can work directly with the Public Affairs Office to get more information out there in the public. We've also provided articles in the board's newsletters, and we'll continue to do that to get the word out and provide some additional information. And this does conclude my presentation. I'd be happy to answer any questions.
Any comments from committee members? Yeah, I certainly agree that in the days of automation that probably you could eliminate the audit by having the where it's just automatically reported.
It does save quite a bit of time, and we're able to audit more. So
it's the honesty thing that's very discouraging, actually. That's discouraging. Doesn't look good, does it? Any public comments on that item? Well, then I think we are ready to move on to the next agenda item. Get it ready. Yes. Let's see, that will be Ms. Ocido. Oh, and Mr. Salgado, it looks like. Excellent.
Good afternoon. This is an update on the polysomnographic registration program. The medical board has created a report based on the renewal survey of renewed and current physicians and surgeons, and we have identified their practice specialty, either their primary, secondary, or board certified in sleep medicine. And approximately 700 licensed physicians and surgeons were identified and were notified via mail with a letter announcing that the registered polysomnographic program is operational. The board's website is in the process of being continuously updated. Currently, we are in the process of developing an announcement page and a fax answers and questions section. The board has seen an increase of telephone and email inquiries regarding the program, and we have been promptly responding. As of date, the board has received a total of 59 applications. 55 of these applications are for the technologist level, and 4 are for the technician level. All of the applicants have been notified via mail that their applications have been received and are in the review process. The board has obtained and filled a new position which incorporates the duties of the outpatient surgery center reviews and the registered polysomnic program. Currently, Daniel Mendenhall and I will continue to handle this program until an appropriate time for transitioning is identified. We're also in the process of fine-tuning and developing the policy and procedures and developments with the new licensing systems that we're in the process of. And this completes my update on the polysomnographic registration program.
Excellent. Any comments? Perfect. And then Ms. Cito on the licensing format.
If you'll take a look at your agenda packet, at the May board meeting, Ms. Yaroslawski requested that the members have an opportunity to comment, engage in discussion, perhaps make suggestions or recommendations for the board's annual report. So within your packet, we've included 4 samplings dating back to 1999. And as you will notice, the years as they went through, we improved the format. It became much clearer. We've also included new data that's required to be reported. So at this point in time, I'd like to open the floor for any comments, any suggestions, recommendations that you would like to make to staff that might make this clearer or perhaps more informative.
Any comments from committee members? Public comment? Wow.
Okay.
Very good.
On that case, we'll conclude this report, and the next annual report will look very similar to this one, the 2010-2011.
Beautiful. Thank you. Now, an update on international medical school recognition, Mr. Warden and Dr. Silva.
Okay, I'd like to start off with, if you would turn to page 140 of your packet, I'll give you a summary of what's basically in the packet, and also in the attachment of which is on page 148. Basically, international medical schools, the board is authorized to approve medical schools based on Section 2084 of the Business and Professions Code, and the schools that must meet the requirements of 2089 and 29.5 of the Business Professions Code, in addition to also Section 1314 of the California Code of Regulations. U.S. and Canadian medical schools are approved through the LCME, which is the Liaison Committee on Medical Education, and they are not part of the same review process, but the review process for the international medical schools is very similar to what a U.S. school would go through that the Medical Board of California does. Prior to 1985, the board staff did not conduct any international school reviews. If the school was listed by the WHO organization, which is the World Health Organization, the staff sort of just issued the code back at that time. That was sort of the standard that people were using. If the school got put on that list, then they were considered a medical school. However, there's a flaw with that, and is that anybody could request to be put on the list. If somebody opened up a school, they could actually get their name put on the list without any review of the school. Since that time, there's another organization, the International Medical Education and Research, was established by the, as well as the Foundation for Advancement of International Medical Education and Research, and it was established by the Education Commission for Foreign Medical Graduates. They've established a list that we call the IMED list, which is the International Medical Education Directory, which lists medical schools that are currently out there internationally. But once again, they do not actually review the medical schools for whether or not they're competent or not. However, ECFMG does make a determination on whether they allow someone to take the USMLE's exams and get an ECFMG certificate, which is a requirement for licensure. Right now, there's over 2,000 plus medical schools, and for our purposes, it's close to 3,000 because any medical school that has any ownership change, name change, or anything of that nature would require us to review it again. And there are several schools that, even though they're on our list, we have approximately between 14 and 1,500 schools on our list. Many of those have had changes, and they need to be re-reviewed, and some of those schools have had multiple changes. All international medical schools originally were founded to train that were, in the old sense prior to the 70s, were generally founded to train citizens of the country that they were going to practice in. That has sort of changed. In the early 80s, they started having medical schools that were being open to train non-citizens to practice here in the U.S. In the spring of 1983, the U.S. Postal Service discovered a scandal involving a widespread production of fraudulent medical diplomas and other practices in some of the medical schools. Specifically, CTEC and CFIS were in the Dominican Republic, and they were run by other people within the U.S., and they were just issuing diplomas, basically. As a result of that, there was an investigation, and that several schools were found to have been falsifying education. Two of those schools have been closed, and all those schools that were licensed here in the United States, medical boards all over had to review these applicants and determine if they actually qualified or not. Several people did not pass that test. So the Division of Licensing realized they needed to take corrective steps to protect Californians from patients being treated by students and graduates from schools that did not meet the minimum requirements of law. The Division's first act was to disapprove 6 of the proprietary medical schools that were either implicated in the scandal or were in violation of California law. Subsequently, the Division conducted on-site inspections of some of those medical schools and developed an orderly process for evaluating new proprietary international schools that attracted U.S. citizens. Of the 12 schools that the Division reviewed in the Caribbean and the Dominican Republic, 4 were recognized, 3 were disapproved following a site visit inspection. In addition, 5 disapproved schools after they failed to respond to our inquiries. In each instance where a school was challenged, our authority to disapprove them, the courts upheld our authority. A task force was formed in 1983 to help develop and sort out the documents of schools and applicants. Upon the recommendation of task force, the Division of License adopted a set of guidelines for the licensing program staff to follow in evaluating medical school education of individuals who are trained outside the U.S. or Canada. The policy was adopted by the Division in 1983, including the concept of remediation, allowing students who are short in training areas to have options to take additional courses and correcting their deficiencies. This permitted a eventual licensure of numerous applicants who attended Caribbean medical schools, and after the guidelines were implemented on an interim basis, the task force conducted a survey of the curriculum of all 128 U.S. schools and used that data to develop the regulations that we now use to evaluate international schools. Currently, there are several medical schools. While in the late 1980s there was dwindling enrollments, school closures in the Caribbean, the 1990s saw an expansion. All targeted U.S. citizens and some Canadian citizens at that time, and all promised clinical clerkship rotations in the United States. In addition, a number of the Eastern European medical schools opened English language programs. The promise to prepare students to pass USMLEs and practice medicine in the United States. Several of the countries involved in this were Hungary, Poland, Czechoslovakia, Slovakia, Russia, Armenia, and recently China has opened several English language programs. The approach to their teaching is that they will teach in the 2 basic years at their country and allow students to either do clinical rotations in their country or possibly elsewhere. And a lot of the elsewhere is in the United States. And some of these medical schools do not have any way of actually knowing when the students actually completed their rotations. So that's one of the reasons why we do that. So even though the medical school might be recognized by us for their education, for their primary citizens, these English language programs we consider to be preparatory schools, and they must meet the requirements of California Code 1314.A1 or A2, so .1 A2. So based on that, you'll see on page 142 we have a chart of schools that we have recognized with site visits, recognized without site visits, English language programs granted recognition depending on the review of the documents, and also medical schools that have been disapproved. And that chart goes all the way over onto page 143. Right now, there's medical schools are opening in lots of places and lots of English language programs. We get telephone calls every day regarding some schools that I'm not even aware of existed and for a while. And we recently received an application from an applicant for school, and the school is not even listed on the IMED list at this time. So there's schools everywhere that a lot of us do not know about. The review process for international medical schools consists of two basic types of medical schools. 1314.1 A1 exempt schools. Those schools are sort of meet the requirement by being a school that was established for the country's citizens and are nonprofit entities, and the schools are designed to teach the citizens of the country to practice medicine in their country. The A2 schools require a much more in-depth review, and they're basically, they can be, most of them are for-profit, and their primary purpose is to teach citizens of other countries. And specifically, we're looking at them for meeting our requirements. So those are the two different ways. How do schools apply to us is depends on how they come to us. Some medical schools know they need to apply to us for recognition, and they submit the self-assessment report asking for recognition. Other types of schools, we receive an application from an applicant. The school isn't recognized for one reason or another. A lot of these applicants are some schools that may have gone to a school that we recognized at some point in time, but there's been a change. So we make a determination to try to determine whether the school falls within 1314.1 A1 or 1314.1 A2. If they fall within the review of A1, we have a streamlined process to try to determine that they actually meet that requirement, and we contact the school with that process, and expecting their school to provide us the necessary documentations for us to be able to legally determine that they meet those requirements. Once we receive all that information is reviewed by the medical board's legal counsel and myself, and once we have determined that that school actually meets that requirement of law, then we will issue that school a school code, and we'll license graduates from that school. For the A2 requirement, they must complete a full self-assessment report, and that is a 25-page document requiring lots of information. We have several of those in progress right now, and at different stages. It is a lot of work for the school. It's very similar to going through an LCME recommendation approval process, and it starts with the school submitting the documents, board staff reviewing it, trying to determine if we received enough documents and what documents they might be. We prepare a report. We provide that report and if after we've determined we have all what we believe we need, we provide that report to our medical consultant. The medical consultant reviews all the information and our report. They will determine whether or not they need additional information. They almost always do, because they have the experience to know what to ask for that the staff does not. That process goes back and forth a couple of times, and then at some point we make a presentation to the board to determine whether or not we believe a site visit is necessary. The board will make a decision on that, If the site visit is determined to be necessary, then the staff will start scheduling the site visit. The medical school has to pay for the site visit. On page 145, you'll see a list of 7 schools that currently have full self-assessment reports here at the board. Of those, we have some that are with medical consultants, some that are almost ready to go to medical consultants, and some that are just recently received and will be going to staff for review. So those are where we're at. This is a very important process to ensure consumer protection to the public, to ensure that we're getting good education and not fraudulent education. There are schools out there that do not require anybody to attend their class at all. You can sit at home and do it. So it is important, and it's an issue that's sort of not just here for the California board. Each state has their own requirements for determining whether a medical school meets the educational requirements. However, we do know that a minimum of 19 states use our list. Other states, I believe, also use our list, but they're not quite as upfront about it with us. So based on that, we also need to reevaluate the medical schools on a regular basis. We have not reevaluated actually any of our medical schools that we previously approved. We need to do that. We are going to be working with our medical consultants to develop a plan on how to do that. And also, we're going to be looking before we do that at our current self-assessment report to make any necessary improvements to it to meet today's educational needs, so that we're actually evaluating them for what we currently need the schools to be meeting. And we have put off the reevaluation because we had hiring freeze, vacancies, and no one to do the job. We're at the point where we have added an additional analyst to help with that, and so we now will have 2 analysts specifically going to be working on that. Plus, we have our 3 medical consultants, and I have Dr. Silva here today with us, and who is one of our medical consultants who is reviewing schools for us, and he's extremely fortunate to have him because he's an expert on international medical schools and has visited many of them. And I'll let you, Dr. Silva, explain to you why this is an important process and why what he sees when he reviews these schools.
Thank you for allowing me to appear before this committee. Just a brief bio. I've practiced medicine nearly 50 years now and over 30 in California. I'm Dean Emeritus of UC Davis School of Medicine. I've been back on recall for a couple of years to assist them in developing global health programs. In addition, I've been employed by the National Academy of Sciences under contract with foreign governments to review medical education systems in a number of countries, Armenia, Georgia, Russia, Kazakhstan, Poland. I'm going to Uzbekistan in late September this year. So I've been around a tree. I've been to over 80 countries. 80 medical schools, about a dozen of them more than once, and I've been over 60 countries in my career. So I've invested a lot of attention in what's going on. I think what I like to do is just provide 4 areas of definition where these schools are stubbing their toes. And a major thing that's going to occur that you have to become oriented to is that the LCME is currently changing a lot of its educational standards. There are 5 sections for an LCME review. One of them are the educational objectives. There are 45 in there. And the 2 that are killers, that are even tripping American medical schools, is one that you have to advertise when a medical student, goes on a rotation, no matter what it is, pediatrics, OB-GYN, emergency, what kind of patients are they going to see? And then the students have to complete a diary to be certain that they're getting a complete education. The other component is that they're asking schools to develop their own program learning objectives, and you have to have data. Are your students hitting areas that will make it important for them to practice medicine in the future? 2 of them these schools can hit, and they've demonstrated that. But that's not all medical training. The two that they hit, of course, is the database, medical and scientific knowledge, and then also patient care. The other areas that we're asking students to provide, they've achieved mastery, are areas like communication and interpersonal skills, professionalism, healthcare systems, what do they know about it, and then reflective to their own practices and personal development. These are all new standards. These schools are not set up to understand the complexities of a country like America or a country like California with all the different ethnicities. It's an important area that we're going to put more and more demands on American and Canadian medical students. That country has obviously a lot of multiple ethnicities. I've been a consultant for about 2 years. I've enjoyed it. Staff works very hard. They're very detail-oriented. I'm not, which helps me to get my job done. But the ones that I see really where foreign medical schools hit a wall, particularly the new ones forming in the old Soviet Union, are related to not providing enough training in pediatrics. Very often they don't have departments of pediatrics. They're housed in internal medicine or family medicine. Also psychiatry is the real big hurdle for many of these schools. No training in psychiatry. They don't even recognize such a thing as a mental disorder. The other area that they continue to have trouble with is assessing their clinical rotations. Many of them list 80, 90 places in the United States or elsewhere around the world, and then you ask them, well, what were the rotations? What evaluations did you complete? How good was the training? It's just a vacuum. They're really just letting the students go out, setting up their own rotations. Many of them are in this country, and dollars are exchanged that are sizable in order for a student to go, but there's no really evaluation. And a student could leave after 2 years or 3 years, some of these are 5-year programs, and not come back for the last 2 years, never return to that parent university. So that's a real problem. The last area that they really are not asked to develop, but they will in the future, they're going to comply with LCME regulations, are all the cross-topic areas that are important for not only medical students, but residents have training to. Cross-cultural medicine, geriatrics, spousal abuse, pain control, neonatal screening, just a whole number of these areas that we have to have cross-cutting, and that they go over to 4 or 5 years of training so that they are introduced to concepts that are important for future practice that are not related to any single discipline. And of course the state has certain laws for CME to keep physicians up to snuff in many of the areas we felt that the medical schools were deficient, and we were, and we're trying to solve that. So that concludes my report and observations.
I wondered if either of you gentlemen, we were briefly on price bill, where the legislature now feels that we do not have to evaluate medical schools. In fact, for someone to be licensed in California, all they need to show is that they passed USMLE and that they have also done an internship somewhere. And even a disapproved medical school would be adequate for licensure.
I think it would be a disaster. It's on a trajectory that will cause harm to patients in the state, bottom line. And I've rounded with students my whole career. We're still rounded with students and residents, trained thousands. And the textbook stuff, the things we can test for, are only a small part. I don't care what your degree is, but in the healthcare professions, there's always a huge amount of data necessary to be successful outside the classroom and the textbooks. And that's what these schools lack.
Thank you.
Well, I so appreciate your expertise and your comments. Any other comments, Dr. Caruso? You've been great experience in education.
The only thing I would say is I've had the opportunity to work with Dr. Silver at the University of Davis Medical School for at least almost 30 years. Yeah. And everything he said is true, and I think he's being a little modest in that regard. So I'll say that. And I had the opportunity as a board member to represent this board in evaluating a school that's on the list, I think the American University of Antigua, which sort of recent, and they seem to have got it.
They got it together.
Got it together. And if that's kind of a model, I mean, for the others to emulate, it would be a pretty good model, I think.
Agreed.
And so, but I agree with your assessment, Dr. Silver. And the thing I wanted to say, though, is I wonder if we, as we look at the requirements, as we look at the contemporary issues, as we look at healthcare reform, I mean, you spoke, Kurt, of the needs for California. And in my view, in a couple of years, when healthcare reform is fully implemented, that is going to suggest a great need. And I don't know how we communicate with these schools who want to be certified by this board, that are international schools, to begin to meet the need, or even if we are considering those kind of policy needs and big needs that maybe go beyond what is prescribed by the code.
Well, I'm not sure about going beyond the code, but of our schools that are on our list, our goal is to contact each one of those schools, because none of them have been contacted for a long time, to find out and get updated information on them, and that is part of the goal. As I said, we currently have the 7 self-assessment reports, but we also have over 100 applicants pending right now that have school codes, well, school issues, and some of those schools may be recognizable and some may not, and some may be A1 schools and some may be A2 schools, but that is a process that we have started to work on, and when we have that, we are proactive, and instead of automatically telling the applicant you're not eligible, if they've applied and we made a determination, we'll make the contact to the school for that, to try to get the school to respond to us. And that's one of the processes we look. We sit down and we try to determine, based on the information we're able to gather, whether we think it's going to be an A1 school or an A2 school. Mm-hmm. If we're not sure, we send out letters to get more clarification. But it is a proactive approach, but it's not a perfect approach because we don't have the staffing to do 3,000 medical schools.
Well, you guys are doing a great job.
Could I just ask Dr. Silva a quick question, and then Ms. Chang? I was just appointed to the USMLE STEP committee, and they grapple with the fact that they can't test for everything. And because if that were true, it would be quite valid to just sit home and study and go take the test. What areas would you think are the things that are most missing? I mean, I've got some thoughts, but I'd be so curious with a real professional, what are the areas that you think can't be tested for and that really we need the on-site? It's got to happen at school and get evaluations.
Observations by us, not only a supervisor of a student or resident, but allied health, because more and more will be performing in teams and a group process. There's no way to get around it. The database is too big, the complexities are too great. But to have that one-on-one evaluation and consistency in advising and feedback. Yes. And of course, you want to help students along the way. Many of these are things they don't know that they're doing. And I think most healthcare professionals that I've been involved with really want to be the best person possible, whether it's a nurse or a physician, no matter. So I think that's the hardest thing. And you must induce in them systems so they can evaluate it. Right. And a lot of it's electronically based. Mm-hmm. You have faculty leaving, a student leaving a clinic after a week. Faculty member could just get on an iPad and punch in right away to the student, to his record, to his advisor, how he performed or she performed that week. So you have a lot of continual dialogue and work with students in trouble. Same thing at the residency level. So it's not going to go away. We're not talking just 4 years. No. We're actually talking whatever the residency period is too. Right. Because the ACGME standards now are what the LCME has adopted as the program learning objectives. And if you talk to these, some of the educators in foreign medical schools, some are very hip. I mean, the Germans get it, French, Italians, Scandinavians are great. You talk to them about a training rubric, and they go, what? And you say to the translator, what? And you have to have a set matrix to evaluate the students. It's not just enough to write a 2-3 line note, but you got to pick out 4 or 5 areas, and it could vary from year to year.
Right.
So it is more complicated.
Oh, totally. Well, I appreciate that. Ms. Chang?
Well, I'm traveling with some of the other state board members. It's actually this job of reevaluating the international school with California is important for a lot of the state because they use our list. They occasionally will say to me, Hedia, when are you guys are going to update your list? I found something in there which may not be there.
Yes.
So I thought this is a great job that you guys are doing. Now ECFMG is talking about having a goal, setting up a list of approved schools, and they have a goal for 10 more years from now in order to come up with something.
Correct.
So do we have any comfort or are we going to see what their criteria are?
Well, they haven't provided us very much information on that, other than that they are looking into it and what their timeline is. But when you look at the information they have, and we're on their email list for contacts, and it's been moving sort of on what I would call slowly for us. So because it's obviously a huge endeavor when you're trying to claim you're going to evaluate all the international medical schools. And so they're trying to look at ways that they can do that, and I don't know if they've evaluated all that yet. I have heard that they may be testing a process right now, but you're still looking at the earliest they were looking at 2023, I think it was, and that's a long ways away, and we have a lot of schools between now and then. So,
thank you for the good work.
I can also add a ray of hope to this committee. The USLMA has been working very hard at old national boards at revising their tests, and they're still projecting for 2015 to come out with new kinds of tests. You won't recognize it. There's no discipline in there that says anatomy, physiology. They're all case-based, but they have a lot of patient demonstrations. So it's going to be like a undifferentiated practice. You walk in the room as a medical student, take the test, and someone's there with a syndrome or a complaint, and they'll test various things that you've picked up about some of the cross-cultural areas. That you can test for.
Janet, I have a question. I am very surprised that I don't see too many Latin American universities. Maybe 1 or 2, the rest are European. They don't apply, or they don't have enough.
They may be the higher category that don't need the inspection if they're
really? Thank
schools,
you.
not for profit. Is that right? If I'm
well,
understanding?
yeah.
What's the reason?
Well, as the schools, they fit one of 2 areas. If they are a government-owned and operated non-for-profit school, and they provide us the documentation for that, then we would consider them recognized. If we're not sure what they are, then we need to contact them directly, or they contact us directly, and they provide us the documentation that we're looking for. But one of the major changes in medical school education is a lot of the government-owned schools that were government-owned are not government-owned anymore. Some of the countries are going into, they're not government-owned, they're still government-accredited, but they're either private, non-profits, or they're for-profits. They've changed. I mean, it's an economic thing, and so that's why I said when ECFMG is saying there's about 2,400 schools. For us, it's more like 3,000 because we have to look at every school change. When they do it, their list is basically the current name of the school, and they might list 6, 7 other names, but they won't tell you what happened to why those names changed or what government changed. We have schools that have changed countries, not list locations, but the countries changed, right? So, you know, when that happens, sometimes they're not government schools anymore.
No, it does not.
Right? So that's why it just depends. There's a lot of changing going on, and we haven't been keeping up with that change, and we're trying to improve our list so that we can get as many of our applicants that we can, at the same time protecting the consumers and making sure that they either fit one of the two processes.
I can tell you, since they asked about geographical area, I've visited Central South America a lot, particularly about 10 years ago. And the countries I was at, the schools are doing a much better job training than what's occurring in the Russias where I go now quite a bit, or the old Soviet Union, Eastern Europe. They're really quite ahead of what's going on in Europe right now.
That I think is a very good news for me.
Okay. But I haven't been to all the countries. I don't know what country you're from.
I am from Peru, doctor. One of the suggestions that I gave the authorities in my country is that during our medical school, we learn in Spanish.
Right.
For us, we think that we know the English very well when we arrive here, and it's not true.
Yes.
And I try to encourage that the whole medical school should be taught in English, like happening in India, Pakistan,
right. China,
Philippines, and the Philippines. That are the three main countries that they have international medical graduates here.
Very smart. Very sweet.
Well, there's a lot going out there, and I know this board has other things, but the expatriates from countries that come to the United States and are successful, very often after 20, 30 years, they want to reinvest in the country of their origin. And WHO has looked at some of the changes occurring. You said India, Pakistan, and I've been with expatriates visiting those countries in China. And they make a hell of a difference in bringing those countries up to the level where American medicine is. It's not that we're the best, but in many ways we can deliver more cures than a lot of these countries can. And they've had an amazing effect on postgraduate education just by their recurrent presentations in their home country, the country of origin. That's all I end with.
Well, I think that kind of segues into item 12, which is the discussion and consideration of a legislative proposal regarding eligibility for licensure from unrecognized and/or actually disapproved medical schools. And Mr. Warden and Mr. Hepler are going to speak to that, but I don't want Dr. Silva to go too far away. We may be asking for additional comments.
It's mostly Mr. Warden.
Okay, so please turn to page 150 of your agenda packet. In this, I'll provide a summary of this basic report we prepared for you. Some of the pages we'll be looking at I'll identify as we go along, and some of the attachments. So the first two attachments are very important, which is attachment 1 and attachment 2. Attachment 1 is on page 150.8. Attachment 2 is on page 150.10. And so to start off with, let me give you a brief summary of Senate Bill 122. Previously, Senate Bill 122 had language in it that would require the board to evaluate and license individuals who attended an unrecognized or disapproved school or who graduated from an unrecognized or disapproved school. Current law in California requires that all medical education that is eligible to be eligible for licensure must be obtained from a recognized or approved school. As we previously discussed, an approved school is an LCME school, and a recognized school is the international school that we recognize through the other process of 1314.1, and whether it's an A1 or A2 school. During the licensing committee, or not the committee, but the board, as I said, has about the 1,400 to 1,500 schools on our list that we recognize, and 10 are disapproved. There are two basic types of schools: the non-government, non-profit schools, primary purpose of teaching their citizens, and then also the school's primary purpose is to teach and educate non-citizens, and that's the two. Right now, the school recognition is critical because the board requires an applicant to be education received from a recognized school. The board does not consider education acquired at an unrecognized or disapproved school as satisfying the standards as set forth in applicable statutes and regulations. In other words, an applicant who did not acquire all of his or her medical school education from a recognized medical school would be deemed ineligible for licensure. Section 2135 and 2135.5 of the Business and Profession Code authorizes the board to issue medical licenses in non-traditional circumstances. However, the board interprets these sections to require that the applicant obtain his or her education at a recognized medical school. Additionally, an applicant must have 4 years of licensure in another state and meet other specific criteria. The specific the language that was proposed in Senate, as I said, is with a permitted exceptions to that. The basic overview of that language that has been removed from the bill currently was this. The language that was in the bill, in the section code that they were going to call it was 2135.7, would have allowed an individual who had attended and or graduated from an unrecognized or disapproved school to be licensed as a physician and surgeon in California if or she met the following. Taken and passed a written exam recognized by the board to be equivalent in content to that administered in California. Held an unrestricted license in another state, country, or the military for 5 years. Had no disciplinary action or adverse settlements or judgments. Completed 1 year of approved postgraduate training and holds an American Board of Medical Specialty certification and committed no acts or crimes constituting grounds for denial. That was the basic requirements. Some of those requirements are actually less than we require of our new applicants at this time because we require a minimum of 2 years of postgraduate training for an international medical school graduate at this time. So that is part of the concern. For the basic analysis, the board's obviously the highest protection for the board is consumer protection, and if Senate Bill 122 had passed with that previous language, and which is the copy of that previous language is your attachment 1, would have jeopardized the board's ability to protect consumers from doctors who may be unqualified due to training received in an educational institution that does not meet the standards set in California law. The proposed language would have eliminated requirements for applicants to complete some or all their education at the school recognized by the medical board. In essence, this would remove the need for medical schools to undergo the review process that was designed to ensure consistency and equivalency with U.S. standards. The recognition process requires the medical education program to provide assurances that its graduates exhibit general professional competencies that are appropriate for entry into the next stage of their training and that serve the foundation for a lifelong and proficient medical career. Under the proposed language, a graduate of any medical school would be eligible for licensure in California, even if the school is not accredited or recognized by the country in which it is domiciled, or even if the board had previously determined the school did not meet acceptable standards. Even medical education obtained online, which is currently being offered through some schools in the Caribbean. So the statutory requirements serve as an incentive for many of these private for-profit schools to raise their education standards to be equivalent of that provided by U.S. medical schools. As I previously stated in the previous presentation, there's approximately 19 states that use the California list that we are aware of recognized schools when evaluating applicants for eligibility for postgraduate training or licensure. The California recognition becomes highly valuable to a school as it has direct impact on the school's abilities of the school's graduates to be able to train and practice in the United States. It's not just California, but there's several states that it affects. The Caribbean schools that have attained recognition have gone through this process of being able to prove that they have met this requirement. Without the requirement, this incentive would be removed and the drive toward equivalency would be greatly reduced. Currently, schools voluntarily apply for recognition for those type of schools. It is likely that schools will no longer subject themselves to this in-depth review or expense for the recognition process it entails. Nonetheless, under the proposed language, these schools would still be able to claim that their graduates are eligible for licensure in California. That's a huge problem for us as protecting our California consumers. Finally, although specialty board certification is a measure of physician skill and knowledge in particular specialty, California only issues one type of license, and that's a license to do any kind of medicine. Okay. And any person who has a California license can practice in any specialty. So we need to ensure that the person has had adequate education in all areas, not just one specialty. There is no way we can determine and guarantee that a physician would practice only in their specialty. You'll see on page 150.2 a possible combination of the list of types of medical school education. I believe I counted them, there were 16 possible combinations. That includes the LCME combinations. And there's quite a list of that, which would open the door to very large number of people that we currently do not accept for application. Almost all international medical schools were founded to train physicians to address medical needs of their country. And as we previously, I won't go over everything we talked about before, but as we previously stated, that is no longer the case per se. And so as the board determined that we needed to do this education review, it is important that we don't go backwards, in my opinion. So, because right now we have the 7 schools who are going through a lengthy process for us. I'm sure that some of those schools may not choose to do that if this law is changed. Okay, and other schools that are they competing against probably will not either. Even though we do not have a fee to apply for our medical school recognition, they do have to pay for the site visits, and the site visits are expensive. Okay. As medical school education has changed throughout the years, more and more schools are opening up English language programs in their countries where English language is not the primary language of education. And so we've seen that in Europe. Now we're seeing it in Asia and China. We're even seeing it in some of the South and other countries. So as Dr. Silva alluded to, the oversight of those students versus the oversight of the students from their own country is not the same, even though they're getting, quote, the same degree. Okay? We need to make sure that we're getting the same quality of education. So, for an example, we are aware of one English language program in China that allows students to arrange their own clinical rotations in the U.S. with nothing going back to the school. Okay, so that's a problem, other than to get a signed paper that said they were there. There's no oversight of what the actual student learned. Other schools in China who have English language programs do not allow their students to go anywhere but at their own medical school. So there's a huge difference between each individual school and how they operate that. In summary, the proposed language will eliminate the need for applicants to have received their medical education by a school recognized by the board. And as I said, it basically eliminates any incentive for any school to even seek recognition by us. It is obvious that there's in Senate Bill 122, they have a concern that there may be physicians that are qualified that don't meet this requirement of law. Unfortunately, the way the law was written, it would have a huge impact fiscally on this board because of the number of potential applicants we could receive. You could expect to see at least 200 during the first, second year, and probably closer to 500, because even though these individuals are licensed in another state, they know they cannot come to California. Many of them would like to come to California and say that, see, my school is recognized in California. It increases the value of where they went to school, and it comes to us. With the way the law was previously written, we would have to accept all those applications, and it would require additional staff of at least one initial file reviewer, one additional senior file reviewer, and the additional time for a manager to review all that, because each one of these would have to go to the ARC for review. The chief of licensing has to perform a review, and the application review committee would have to meet. Currently, the application review committee meets no more than quarterly when we have applications, and generally for no more than a half an hour. It would take between close to 15 to 30 minutes per applicant to be reviewed in this process. So you were looking at, that's a lot of applicants for the ARC to review, and a lot of staff hours. It takes a minimum of 20 hours to prepare an application review committee, a memo, and provide all the necessary documents just for the senior analysts, and then for the managers and myself to review it, not to mention the preparation for the board members who have to prepare themselves for the meeting. So at 200 applicants per year, that would mean the ARC would need to review approximately 50 applicants a quarter, and that equals to approximately 24 hours per quarter, which would be sort of unreasonable for one ARC committee. So that is a fiscal impact with the way the law was previously languaged. There would be additional costs for the board meetings, additional costs for ARCs. Probably would have to have them at different times within the regular board meeting. So there's a lot of extra costs involved in that. To address some of the concerns that Senator Price was trying to address, the board has come up with some proposed alternative language for you to consider. That is on page 150.10 of your packet. So in that, the proposed language that we think would provide greater consumer protection for Californians, but still sort of reach the goal that may be acceptable for the senator, and maybe even help California in the long run. It would be the following: we would increase the number of years of limited practice for those who just went to an unrecognized school to a minimum of 10 years, and for a person who went to who attended a disapproved school, that would be increased to 20. They'd also be required to have ABMS certification, and also more time for postgraduate training. So those are some of the differences that the board should be looking at on those. The fiscal considerations for the alternative language is a little bit more difficult to provide analysis for, due to that there's other options for the board to consider. And I'd like you to look at the staff recommendations on page 150.6 for some of those options. Some of those options would be trying to determine if you needed regulations or to request for regulations as part of the alternative language to identify which applications would require ARC review and possibly which ones would not require ARC review, which would have an impact on how much that would impact the board. So those are some of the recommendations. Specifically, staff is requesting that the board examine the proposed language for 2135.7, determine if the requirements are adequate for consumer protection, 2, determine if the years of licensure are adequate for consumer protection, 3, determine if there should be a provision for the possible development of regulations to implement the provisions of hybrids as listed in the previous section of the 16 different types of combinations of schools, such as attending a disapproved school but graduating from a recognized school, attending an unrecognized school, graduating from a recognized school. Those are things to be considered, and determine if all these applications need to be reviewed by ARC or if that should be addressed in regulations. So that's sort of where we're at with this possible. We do believe that some kind of language will be put back in Senate Bill 122 to address this issue. We would like to try to make it so, offer a suggestion to the Senator Price and his staff of a possible alternative that provides better protection and less cost to the board.
Any comments?
I mean, the obvious comment, right? It's like we're trying to protect the public by saying 10 years and 20 years, but what we really want to say is no, right? They're unapproved schools.
Well, I think the difference is, if I may, on 150.8, you saw what was coming out of 122. In 150.10, this would be a proposal to go back in, essentially, to 122. Dr. Diego, you're exactly right. What's on so-called this proposal clearly differentiates between a disapproved school and an unrecognized school, under the theory that an unrecognized school may be one that we haven't gotten to yet. Mm-hmm. But a disapproved school is something different. It's something that we have gotten to and we have looked at, and it said it does not conform to the board standards. So that's why the difference. We have to remember that too, when you're talking about 21, this type of thing, this is not a denial, this is a question of eligibility. Eligibility for a license, they're not exactly the same thing. And finally, as one of the legal counsels to the board, my colleague here talked about regulations. I would suggest that regulations, a phrase or a clause, a subdivision D should be added if the board feels this way, if the panel feels this way, because ultimately this committee will be making a recommendation, if it so chooses, to the full board, that the board have regulatory authority to implement the provision of this section. I think there is some room for regulations here. If you look at the bottom end of subdivision A1B, you'll see, for the purpose of the subsection, we may combine the time of an applicant held an unrestricted license in various states under the theory that, if you're good in a lot of states, perhaps you don't have to be good in one for the entire 20, and I think that would call out for regulations. Also, there may be some circumstances when we talk about closed schools or schools that are no longer operative. There may be issues where you simply cannot get the necessary documentation because they may no longer be in existence. So this is modeled at 2135.7 on 150.10. It's loosely modeled on, as Mr. Warden pointed out, the existing 2135.5 section, which does allow the board to grant a license under unusual circumstances. The circumstances in this case would be that the applicant received whole or part of their education at a disapproved or an unrecognized school. So with that, I'll shut up and answer any questions anybody could have.
And I'd like to just add one more thing. It is required that we have primary source documentation in medical school education, so that's also something you need to consider. It's not only required by our law, but the federal government, I have to sign every year that we require primary source verification. So they don't even let me do it once. They require me to do it every year. So,
it's really important. Let me tell you why I think it's important that we have to verify those schools. We talk about Sabat University, and recently a neighboring kids of mine, my neighbor, went to Sabat and then come back and telling me that they actually have very good standards there, and because the first semester they let go 40% of their students they cannot pass. But you look at how many people are going there. What I'm saying is, the people who goes there, that it's not like the same standards that the students come to our medical schools. They are low. I think they are people like me probably who wanted to go to medical school right at this moment, and I cannot get anywhere else, but I can get in Sabah if I just apply and pay. I will not make it. I shouldn't put myself down like that, but you know what I'm trying to say. So the standard is there because they are a qualified school, so they keep a standard there. And I was impressed with that because she was working very hard. She said to me, I have to work hard in order to maintain in that school. So I truly believe the evaluation of the schools set that tune. Because otherwise, if we don't do it, there is not a true systematic way in the United States right at this moment. The only people, you know, New York, it's accepting all 15 offshore Caribbean schools without any judgment. Anybody who goes there get accepted and goes into New York. And they can work there and then get their rotation. They buy their rotations and they get that done. So, you know, I'm torn at this moment at, you know, the compromise that we have to come with it. But I wanted to tell you how I feel is we should be, if we wanted to do any compromise, be tight about it.
If I may, one of the things that the board's tried to do in this proposal is essentially preserve the existing system that it has now, because if you go to a recognized school, or if you go to an American school, once you fulfill the licensing requirements, the 2 years of postgraduate training and pass the USMLE, all steps, and have necessary education, you are eligible for licensure. This would suggest that in order to make sure that there is still some value in the medical school's recognition, that there are certain additional requirements to be eligible for licensure if you have not gone to a recognized school. So that's the medical board's attempt to sort of preserve its existing recognition program.
All right. Okay. I guess I'll buy that because I just one more point. I think the point about if it's not a approved school, I will have a hard time swallowing that. Saying if it's not approved.
You mean a
school.
specifically disapproved school? We looked
Yes.
at it and
We
it was
looked at it,
disapproved.
we
You see that as
disapproved the
very
school.
different from not approved because maybe we haven't gotten to it yet.
Yes. Yeah.
Thank you.
At that point, I felt we shouldn't take it. That just.
Please, any other comments from Dr. Corione? You must have a thought about this.
Well, I was just going to say, at least it's 20 years that you're putting into it, so most people probably after 20 years of practicing in somewhere in the United States must be good at doing medicine if they intend to come get licensed in California. And I would wager to bet there's not very many who are going to wait around 20 years to then get a California license. So I don't like the compromise, but there it is.
The only thing I would say personally, and I want to hear from Dr. Bishop, about the years, I'd feel more comfortable that they be in one or perhaps two locations, because I do think there is an issue with people moving from state to state or location to location to avoid a problem. So lack of a problem that we're aware of could be moved before they could find the problem. Dr. Bishop.
Yeah, I just want to be very cautious that we don't dilute our standards significantly. We have a great practice of medicine here in California and in this country, but I think placing language out there that says we'll allow somebody to get a license from a disapproved school for any reason sends a terrible message to people. And I think our medical school admissions process here is flawed in the United States, but it is what it is, and it certainly is better than others. And I know anecdotes are always dangerous, but let me just tell you an anecdote about a very wonderful individual that I've worked with who graduated from a foreign medical school, did their residency in that foreign country, and then came here and had to repeat their entire residency because they were so totally incompetent in their specialty. And when they started, they were a wonderful person, and they finished up the residency here and were awesome. But prior to that time, they were not functional. So I just think we have to be very cautious when we do anything. And I suspect your medical school even was an approved one, but nevertheless, the training was just not what we get. And so I want to be very cautious again not to create a two-tier system of those coming from our schools and those coming from other schools. And ultimately, I think it just is I don't totally disagree with doing something, because I think it's not, if we have great doctors, where they come from, that's great. But let us just be cautious before we jump with 2 feet into this pond, because it might have rocks in the bottom and glass and things like that.
You know, and I so appreciate that. The one thing that gave me a little comfort with respect to the compromise is that in a way, we're setting the bar a little bit higher in terms of requiring ABMS certification, and not just 2 years of some form of postgraduate training, which could be, discontinuous years. So, but I do appreciate that argument that we don't license to specialty, so that person could do anything. But at least with the ABMS, we know they have. I can't think of an ABS program that has less than 3 years to be board eligible. So I'm thinking indirectly that probably gives us 3 years in a program. Can you think of a specialty that's less than 3 years?
No, I think they're all three.
So Dr. Silva, could you help us out with this?
No, I'm trying to, and nothing's coming up.
So I think if we require ABMS, we probably have 3 years of observation.
Three.
I think.
I mean, there are some limited boards, but you can't take them if you take the standard.
Correct. So I'm thinking that perhaps by having the ABMS certification there, we're going to have 3 years of postgraduate education in programs that we do have a handle on. Do you have any I guess we can move to public comment, so if I can ask you, do you have a feeling about this compromise language?
I like compromises. Not everyone can walk in the same set of shoes or the same circumstances. It allows for tolerance. You have reasonable people on the board and take these one-on-one. I don't think you'd be jeopardizing the public very much with that track record. I do know, I haven't served on the Defense Health Board for 6 years. President Bush put me on, and President Obama extended me 3 years. That if they come in from an international medical school and are active military, get citizenship, they know within months the caliber of that person.
Okay.
They would never survive 4 or 5 years in the military unless that practitioner was really good.
Okay, that's really helpful. That's helpful. Thank you.
I would like to, with the training that we have, is when I start my residence, they told me this is like the military. And I said, yes, sir. And that's it.
With that, I think we're ready then to.
Madam Chairman, if I could, I'm sorry. Perhaps before we entertain public comment, if we could, the committee could perhaps consider a motion, and that way anybody who wishes to offer public comment could be directed to comment on what the motion of the committee is.
Okay, very good. May I have a motion from the committee regarding, are you moving that we accept the compromise language? Okay. All right, well then I think it's time, and I think we've had board comment. Any more specifically, now that we have a framed motion?
Can I ask one more question? Certainly. We have to compromise?
No.
I'm sorry. And if we didn't, if we said no, unapproved schools remain unapproved schools, then what do we get?
To be candid with you, Dr. Diego, I think that's more of a political question than a legal question. If I'm fairly confident, I don't work in the legislative arena. Ms. Mose could probably answer that question, but it seems to me intuitively that this issue will be addressed legislatively in some manner.
Could we ask Ms. Whitney to comment on that?
And I'm sorry to be a stickler. Did the motion include also the suggested amendment that we would have some regulatory authority in there to implement this?
I would think yes.
Okay, thank you.
No, does anybody, I guess I'm the one who felt strongly about if it's a disapproved school, we shouldn't give them a license. But is everybody okay with that, or can I make a friendly amendment to it?
Well, I think that's what Ms. Whitney was saying.
This, we want to know what our latitude is, since we'd all prefer to say no completely, so perhaps you could give us a little context for what our realistic options are.
So what your best bet is to have a motion with a second and listen to public comment. We do have staff from the Senate Business and Professions Committee here who can address you, and I know there's some other folks who can address you, and then you can make some amendments to that motion if you so choose, but you need to hear from the public and the author's office.
Thank you. I think then are we ready to invite our public comments? And it looks like Dr. Mitchell Feynman wishes to make a comment.
Chair Salmonson and committee members, good afternoon. My name is Mitchell Feynman, and I'm a triple board certified rheumatologist and internal medicine doctor practicing medicine in South Carolina. I support the change of the law and the policy of the Medical Board of California to permit physicians who have over time and with appropriate credentials practice medicine in California. After my graduation from the University of Southern California, I attended World University School of Medicine in Santo Domingo, Dominican Republic. Upon learning that the school was not academically on par with USA regulators, I proactively applied to Ross University School of Medicine, an approved California foreign medical school. After their review of my medical records, or my academic records, I was admitted as a second-year medical student. From that point on, my medical education and career has been, by all accounts, fulfilling, rewarding, and successful. I did several of my clinical rotations at Boston University. I was accepted in postdoctoral programs in 1987 at St. John Hospital and Medical Center in Detroit, Michigan. I completed my rheumatology fellowship in 1992 at Washington Hospital Center in Washington, D.C. I took my boards in 1990 and 1992. I obtained licenses to practice medicine in Florida, the District of Columbia, Maryland, and Michigan in 1990, and South Carolina since 1996. I have maintained professional and academic affiliations, and I have practiced medicine in the United States for over 20 years without any disciplinary actions against me in any jurisdiction I have practiced medicine. I think I have proven to the public at large and the medical community that I am competent to practice medicine and protect consumers. I have learned that the interpretation of the law by the Medical Board of California does not even permit me to apply for licensure, not because I am not qualified or did not graduate from an approved foreign medical school, but because a small part of my medical education was at a disapproved school. That interpretation is not the letter of the law. I graduated from an approved medical school, which is the law. I have met all the other requirements under the law. As such, I support the recommended change in the law and policy to permit me to practice medicine here in California. Thank you very much. And if you have any questions, I'll be happy to answer them.
I appreciate your comments. Next, I see Mr. Stuart Hugh. Shea.
Good afternoon, members of the committee. It's nice to be before the medical board again. To some of you who don't know me, I served on the medical board for 7.5 years in the 90s and have an active healthcare practice. The only thing that's missing here is Anita Scurry today. Yeah. But that being said, I do represent Dr. Feynman and a number of other physicians who have attended foreign medical schools. And one of them asked me to remind you that he was chairman, president of the medical board at one time, Dr. Robert DeHunko. And so foreign medical schools do play a major role in California medicine. But we are all in support of this motion because there are people like Dr. Feynman, and I have another client, Dr. Suyaba, and she practices in Connecticut, licensed in Connecticut, licensed in New York. Went to a school that no longer doesn't even exist. It was disapproved. She's double boarded. Has a fairly good proven track record. She hasn't only practiced medicine for about 12 years. She would like to come back and matriculate back to California. Her practice is essentially to the needy, the areas of don't have access. She practices in the lower areas of Harlem right now and New York and the areas in Connecticut that don't have medical care for free, pro bono. She's fortunate that her husband's fairly well off. These are people that have and willing to prove themselves and have proven themselves. And Dr. Feynman, who's been here 20 years without any problem, over 25 years practicing medicine, he's got a little glitch for 1 year that was at a disapproved school. And I bring to the attention of the board, the school was neither disapproved or approved at the time that he left. So it's a little anomaly there. The other physicians that I represent, one of the other physicians I represent, he's faculty member at Baylor University Medical School. He's double boarded. So it's interesting, we have physicians out there that have gone to foreign medical schools, disapproved medical schools, that have proven themselves, and there's got to be a mechanism if they choose to come to California that they are eligible. And that's a key word. They're not getting their license. They're eligible for the application to apply for medicine. They're not saying that just give me a license. Give me the opportunity for the medical board to go through the licensing process to see if I can be licensed in the state of California. So I want to make that nuance pointed out, that you're not carte blanche approving them for medicine. Your carte blanche, what you're saying is, yeah, you meet some requirements, we'll make you eligible to apply and let the process find out whether they really are able to practice medicine. Thank you very much. Good afternoon.
Thank you. Next, I have a slip from Christetta Summers.
Good afternoon. I'm also here with Dr. Gargat, and I think on a slip further down you'll see the two of us
both
together.
names, so you can pick your order.
Thank you.
Presentation.
I will go first. I am from the law office of Albert Robles. I am his assistant, and our office represents physicians such as Dr. Gargat, who graduated from foreign medical schools and are seeking admission here in California. I think the points that were made by the speaker before me are points that we would also agree with, and in particular to stress that these standards that the committee is looking at are not admission or licensing standards per se, but whether the applicants are eligible to be considered for licensure. It is our position that the statutes as presently constituted already give this board the discretion to decide whether someone who graduated from a foreign medical school under certain circumstances should be allowed to practice here in California. We don't see necessarily the need for SB 122. However, we are supporting the bill to the extent that if there were any issues about its interpretation, and obviously there are, that the bill would make clear that in fact there is a path for foreign medical students to become licensed in California. The regulatory climate that existed in the 1980s and continuing to the 1990s was a very different regulatory climate than exists today. In the context of information society like ours, where you can, with the push of a button, find out everything that you would want to know and more about any individual, the concerns that cause the promulgation of the restrictions for foreign medical students no longer are as valid as they once were. Today, you cannot produce or even reproduce a certificate that is fake. It will be discovered well before it even reaches the medical board or any committee of the medical board. So the concerns that cause the regulations in the first place and the restrictions on medical licensure of foreign medical students are not the kind of regulations that would be as important to have in today's climate. The premise of Senate Bill 122 is that there can be really good doctors practicing in California who would not otherwise be allowed just because at some point in their life they attended a foreign medical school that was not recognized by this board. You've already heard from Dr. Feynman, you've heard about other doctors, and you'll meet Dr. Garagat in a moment. The reciprocity requirements that exist in the code already and that are part of SB 122 are very separate and distinct as a path to licensure than the path for initial applicants. What protects the California consumer in the reciprocity requirements is that there has been a practice that's been developed. There is a past and a history that the board can assess. And for Senate Bill 122, it has determined that 5 years should be sufficient. I believe 5 years of practice is a long time anywhere in this information age where you can practice and not have an adverse judgment or not have some type of proceeding against you. So that I think 5 years is sufficient as protection for the consumer for eligibility. Again, it is not for automatic licensure. And so I would hope that the board would entertain or reconsider the compromise solution as being too rigid or too strict, because it would still prevent a lot of really good doctors from being brought into California. 10, 20 years wait or history of practice, by the time you've had that, as one of the board members pointed out, you're probably in your years closer to retirement, and you would not likely be uprooting to come to California. So it would cover just very few people and would not address the long-term problems that we now see with healthcare reform and that we anticipate with the shortage of good doctors here in California. Thank you.
Thank you. Ms. Doctor?
Thank you. Good afternoon, committee members and board members. My name is Roddy Garagat, and I am a board-certified pediatrician working as a pediatric hospitalist. This agenda item, as it's important to many others, is particularly important to me on a very personal level as well. Let me first say that I have a great deal of respect for the board's mission to protect the citizens of California and applaud your efforts to ensure that consumers receive the best care possible. I understand the concept behind the approval list of medical schools. However, as we all know, graduation from a school on the list doesn't necessarily guarantee one's abilities in the real world of clinical medicine. If I may, I would like to briefly just shed some light on my background and my personal reason to seek licensure in California. I hope to provide an example of the type of physician that could benefit from the changes and perhaps your consideration. My decision to pursue medical school overseas was not based on my inability to gain admission to a California-approved medical school, but rather to gain a practical experience in underserved countries. I was 20 years old at the time and basically wanted to save the world, one child at a time. And as an East Coast native, I never had an intention to come back and practice in the state of California, and had no knowledge at that time even of an approved list or a disapproved list of schools. It was only during my third year of medical school that I did gain knowledge of such restrictions in certain states. In regards to my clinical training, all of my rotations through medical school were completed at university hospitals, and in fact, with a great deal of oversight from attending physicians throughout my entire clinical training. I was actually one of the students that had all of my clinical reports sent back to my university, took the same tests during my clinical rotations as the U.S. medical students did, and passed all of them. After completing my clinical training, I completed my residency training in pediatrics at the University of Texas, and during which time I actually did win awards for teaching both residents and medical students, as well as awards for research activities that I carried out. I was also subsequently offered 3 fellowship positions at the University of Texas. Since I completed my residency at the University of Texas, I've maintained a completely impeccable record without a single complaint or violation of any kind, and practiced medicine in multiple states and continuously since completing residency. In 2006, my wife actually gained acceptance into veterinary school here in California, and due to this reason, for the past 6 years, I've actually been commuting to Las Vegas for work and living in California. As you can imagine, this has not been easy for me or my family, but the regulations that we adhere to really have left me no choice. During this time in Las Vegas, I've actually been appointed as the Vice Chairman of Pediatrics at one of our hospitals, as well as the Medical Director for Inpatient Pediatric Services at one of our other hospitals. My current responsibilities actually include training, U.S. graduated residents as well as U.S. medical students. That being said, I cannot express in words the deep desire I have to be able to practice finally in the state of California, where my family and I live. Currently, I've actually been offered 3 clinical positions in the state of California, all of course contingent on my licensure. I do feel that the confidence of my peers in my abilities is a much stronger indication that I'm a qualified physician over the fact that I may have attended a foreign medical school over 10 years ago. I truly hope that my personal story can show that there are in fact qualified, ethical, and dedicated physicians who may not have attended a school on California's approved list. And I do hope the board can consider applicants on an individual basis if possible, rather than solely based on the school that an applicant attended. Thank you very much for your time.
I thought we had a hint that we might be hearing from Bill's sponsors. I'm not seeing any more speaker slips. I'm missing speaker slips? Oh, okay, very good.
I didn't fill out one. Okay, thank you.
I think they want us to do that.
Okay.
We're very law-abiding here.
Thank you. My name is Bill Gage. I'm the Chief Consultant for the Senate Business and Professions Committee. Been a consultant with the committee for 20 years, been with the State Senate for 25 years. Worked closely with the Medical Board on a lot of different issues over the years, and with their committees. I think we've resolved some very important issues for the board over the years. And hopefully we can resolve this one today. What happened is it came to the attention of the senator that, as you've heard today, that we have physicians that we're in a situation that they've been practicing in other states for many years. And there are states, obviously, that approve certain international schools that California has not. And they've applied to California and have been refused licensure because one of the schools is not on the list or has not been approved as yet. Senator felt that the board, and we thought the board possibly had discretion in terms of looking at a physician that had actually been practicing in another state for a number of years, especially if they're board certified, and could make a decision, even though they had gone to an unrecognized school, that the board still was able to possibly grant them a license to practice in California.
We actually went to our legislative council and asked them if they thought that based on what's in the codes, whether or not the board did have discretion. They thought the medical board does have that discretion. But then we discussed it with the medical board, with the staff and legal counsel in terms of whether it's clear enough in terms of what the board could do under this situation. And I think we all agreed, we had a meeting with the senator, I think we all agree that the language is not clear enough in terms of what the board can do under these particular circumstances. I think the senator felt strongly, we're now going to be dealing with national health care. We do have a shortage of physicians in California, that we at least need to be looking at the idea that if there are physicians that are practicing in other states and are in good standing and have been practicing for a number of years, that they do have an opportunity at least to apply for licensure in California, and that just because the school itself may not be on the recognized list, that the board could take into consideration that they have been practicing in another state for a number of years and that they are board certified. The language we came up with at SB 122, I actually just had counsel talk to your legal counsel. I think the 5 years was just an arbitrary number of years in terms of what they thought should be necessary. We actually, and the only reason we had to put in language, we actually wanted to wait till we had this meeting with you. The only reason we had to put in language in SB 122 at the time, because it was in the Assembly Business and Professions Committee, we had to give them a heads up that we were going to be dealing with this issue. And so they actually asked us to take it out in committee. So it was just the opportunity that everybody knew we wanted to deal with this issue, but at the same time that we would come back to you as the board and make some determination of what would be the best approach, what would work for the medical board. I think your staff has done an excellent job of laying out the problems, potential problems, everything from costs to the number of applications they may have to deal with. But I think the bottom line for the senator is just that if we have a situation of physicians that have been in good standing, practicing in other states, that at least the board does have that discretion to look beyond the fact that the school is still, somehow it's still on an unrecognized, it's on the unrecognized list or unapproved list. And there are situations, I mean, you have a few schools that are disapproved. I mean, certainly you don't have a lot of disapproved school, but I know there's one school that's more recently been put on the disapproved list. So I'm not sure how the senator feels about the idea of 20 years for disapproved schools versus 10 years for unrecognized schools. And we may get into this whole situation in the legislature about what years are appropriate in terms of that. But at least for now, at least we know the board, from its standpoint, is feeling that 10 years should be at least the outside number in terms of somebody who's been practicing in another state before they feel comfortable making that decision about that person who's come from an unrecognized school. I mean, I know that 19 other states follow the medical board in terms of its approved list, but that means there are 31 other states that does not. So it's just very much concern for us. You currently have a backlog in terms of schools, foreign schools that are actually being approved. That has to be taken care of. And I hope that, when I was listening before, we were talking about the other issue about approval of international schools. I think the process itself is something we can look at more closely during our sunset review of the board and come up with a way. First of all, I think all your costs should be covered. We just went through with the nursing board in finding that they expend a lot of their own money and staff time in terms of approving nursing programs. And so we now we're carrying this year actually to assure that their costs are covered, both from the time of application to any site visits to anything else that the board has to do in the context of approving schools. That should be the burden on the schools, not the burden on the medical board in terms of their costs and staff time. With that, as I said, The compromise language, I think the only issue may be the number of years, but I think it's a good start. And I just want to let the board know that there may be some more discussion about the number of years you have so far proposed. With that, I'll take any questions.
In light of the fact that it seems like it's going to take a lot more time and effort to perhaps vet these applicants, would you feel that the differential in the cost to the applicant would be in reason?
I would. As I said, we always
would that be fair? I mean, you feel that'd be a fair expectation?
Certainly. We always feel that the costs of that, the applicant and the application costs and the administrative costs should be covered by those that are actually applying for the license. In many of the other health boards, we've assured that those costs are covered, and if they're not, they should be, and it's something we should change in terms of if we have to raise the fee. I think in terms of
what I'm hoping for, though, is not to raise the fee for all physicians to cover the costs of a few.
Right.
Such that
exactly. Those would be strictly application costs.
Yeah. Great.
Excuse me, Bill. Yeah. Just for the record, I'm talking to Dr. Feynman. My clients would be happy to pay.
I assume so. I assume so. And I wouldn't want to make a draconian thing. I'm just saying, let us cover our costs.
But what I was talking about also is I think the schools need to cover the cost of application.
Absolutely. That is
There's no reason that cost is not being covered currently. Site visits, I think we want to look at, because as I said, we went through the nursing board for the past 3 years in terms of streamlining their process. And I think there's a few other ways that we could streamline the process, especially now that you have a backlog. I think there are things we can do. First of all, cover all the costs. But secondly, maybe we don't need a team site visit. Maybe the fact that you have a medical consultant that starts looking at the school initially, and that's what the nurses board does, is they have a nursing consultant that follows it all the way through the process, and then they come back and make the recommendation, and then staff comes forward to the board, rather than this back and forth between the board and a site visit and all these other things. So I think there's some things we can talk about in terms of changing the process, hopefully make it more streamlined, but also covering your costs in terms of looking at these international medical schools.
Can I?
The only thing, this is sort of off topic, but only with site visit, and since our hospital is just going through JACO, which now, as you probably know, is no longer announced. It's unexpected, and I do think that's something to think about for site visits as well, because I do think they can prep so much if they know they're coming. So perhaps we have to buy the tickets and then ask to be reimbursed so they don't know we're coming, but that's an aside. Any other comments with respect to this?
I'm just asking on that same point that if the board has already disapproved that school, can we not putting it in the regulations anywhere? Pretty much is because I really do not want the Medical Board of California approve some license to some people who went to a disapproved school. Would you have any problem with that?
Not really. I mean, in the code, it specifically says the board does not have to consider an application of a person from a disapproved school. When we ask counsel about that, it says, well, at the same time, doesn't mean they can't approve the person from a disapproved school. I mean, that's when we got into this whole idea of whether the board had discretion or not. And so the board has currently, under the code, we believe the board has the ability to say, if you're from a disapproved school, you do not have to approve that person from a disapproved school. But at the same time, it doesn't say the board cannot do that. But again, that's where we were unclear. And so that's, I think, when we talk with your legal counsel, well, let's make it clear then. If we are going to be talking about those physicians coming from approved schools versus disapproved or unrecognized, that we set some parameters in terms of what that's going to be and how that approval process is going to work.
Bill, you mind?
Yeah, go ahead.
Hi. To be clear, though, for Dr. Feynman's one of those physicians, he went to a school that was non-approved at the time, Mundell. He figured out on his own wasn't up to par. He transferred out. After he transferred out, got accepted into Ross, graduated from Ross. While he was at Ross, Mundell got disapproved. Now, if you say you can't, if you attended any disapproved school for any portion of his medical career, education, he can't be licensed in the state of California. And so and here he is, he's triple boarded. He's practiced for over 20 years in the United States, done all his rotations in the United States. And I think that would be a crying shame. And he actually, all his family is now out here in California and thinking about, would like to come out to California, back to California. So that would be the issue.
Yeah, but to due respect, we cannot just do a legislation for one person.
Well, on that, Bill made a good point. And mind you, this is only an application. This is only eligible for application. You do not have to accept the application.
I know you all make that point, saying you don't have to accept that. But if the criteria is saying that you're supposed to look at this and accept them, then it is accepting. Whether I don't know where else that I can look and say not approve this person, if the criteria is exactly the way it's putting.
It says it's eligible for application. I think it's quite clear it's eligible for application. And you would be eliminating anybody that had attended even one class at a disapproved school. What if, and by the way, Dr. Feynman had to take other classes to get up to a second year. He graduated from an approved school that actually vetted through his records and made a determination that he was qualified to go, and he actually graduated from an approved school, but he did attend some education at a disapproved. I have a physician client of mine. He was a master, the American College of Physicians. He's a master physician. He had to hang up on his license in another state because he had no undergraduate degree. He skipped college and went to med school, and they had a problem with that. Right. And so there's a typical example where it'd be out of the ordinary.
Yeah, I think I'm going.
One more point,
okay, because I think we can't do this as a hearing for individual cases at this point.
And not only that, the school he went to has vetted the other school that he went to is not approved. That's a different case about a person who went to a place where it is totally disapproved school.
Yeah.
So I think if the school which he went to,
I think I've gotten a little word from our attorney. We might be in jeoperdy if we're sort of hearing this case.
Respectfully, everybody, I would suggest we not talk about onesies and twosies and individual applicants. Perhaps the best way to consider this, because I have a very small brain, is to consider it like this: the attendance or receiving of a resident course of instruction, one class, two classes, 1 hour, or you're driving by and you got a good thought as you drove by, or whatever, is that it would no longer serve as an automatic bar for licensure. That's probably the easiest way to think of it, is that just by attending or graduating from an unrecognized or different or disapproved school, that does not automatically bar you from getting a physician's and surgeon's certificate issued by the medical board. This bill would do, leaving away, casting aside the permutations and the years and all that sort of stuff, would essentially, as many speakers have said, make you eligible for consideration to receive a license. You're not automatically going to get a license. What it does do is allow you eligible to be considered for a license, which is kind of a change from the current status quo of the board was. Right now, it kind of serves as a de facto bar to licensure. And I believe that's what the senator is trying to change.
What we're trying to do is set a threshold. In other words, you shouldn't have to consider those folks, obviously, that don't meet the threshold, whatever that we come up with, and right now it's the 10 years. But that it's discretionary, though. It is still, we believe, the board should have the discretion. And we're not saying that you have to. We're saying we're not making a mandate. We're just saying you should have discretion once that person reaches that threshold, whether or not they should be licensed in California. And that's why I think we have a little problem with the 20-year idea of a school that's unapproved or disapproved, because we are turning discretion back over to the board in terms of if you reach this threshold, then it's up to the board whether or not this person would be licensed. We're not saying just because they reach the 10 years they have to be licensed if they're practicing in another state. Just so you know, I think we were looking at most of our other health boards. They all pretty much have the discretion to look at practice in another state and approve that person. And there's no timeline. I mean, if you've been practicing 1 or 2 years in another state, you're still eligible to be considered, even though you came from, in their circumstances, an unaccredited school. Now, obviously, we're in a unique situation that we don't accredit foreign medical schools. It would be a lot easier for us to deal with that if we had an accreditation of these schools. But the idea being that since we don't do that, it's state by state that we're dealing with. But from the senator's perspective, shouldn't we be considering the fact that a physician has been practicing in another state for a number of years without any problems, board certified, and that there may be some problem with the idea of the school having been recognized or not by California?
Do we feel ready to vote on our motion? If there are any more comments we're ready to call the question.
Now, the motion that I have with the second is that the committee would recommend, would adopt this proposal. I'm sorry. The committee would adopt this proposal and recommend its consideration by the full board tomorrow, with the addition of the regulatory authority that I discussed when I was waxing eloquent up there.
Are you are you going to say was that portion you just said is a criteria for looking at it, not necessarily approving it? Is that part of this motion?
That's what it is, right?
It's a recommendation to the full board, ultimately the full board.
Application, right.
Okay, and the other one is I'm just asking the rest of the board whether, committee, whether they'd be interested to take a friendly amendment and taking the unapproved school portion out.
You would have to ask the maker of the motion and the second whether they would take that as a friendly amendment.
No? Okay.
Yeah, I think, in all fairness, we can have a discussion with the full board, and at that point, if the full board feels they want to do that, at that point, we can take it out. That way, we're advancing the entire package, and then we can let the full board decide at that point.
Okay.
All right. Then we're ready to have a vote. Do I have all in favor of the motion as stated, and it's merely a recommendation to the full board that we accept this stated language? All in favor?
Aye.
Any opposed? Do I have one opposed?
Yes.
Okay.
I oppose.
It does pass. Now we are still not done, but we're getting close now. Let us have, please, agenda items for the next meeting, which will be in October, the 25th and 26th in the San Diego area.
I had requested to put I'm not even sure, look at the supervision for our midwives and
Could we broaden that to say allied
professional, yeah, their supervision, what that exactly entails. The compliance, that's what we're at.
Thank you. Okay, any other items for the October meeting? I'm sure you're free to suggest anything.